Welcome to Spainguru. I'm excited to introduce Ainhoa Manero from Sterna Abogados, a top law firm from Madrid specializing in immigration services. Ainhoa leads Sterna's dedicated team, expertly guiding on Spanish immigration issues, including nationality, work permits, and visas. Spainguru has proudly recommended Sterna for years. Today, we dive into the intricacies of the Spanish Non-Lucrative Visa. What are the must-know financial requirements? Can your family move with you? Can you work under a non-lucrative visa? Can I transition from a non-lucrative visa to a digital nomad visa? How do recent legal changes affect your application? Can dual citizens benefit from the 2-year citizenship fast track? And what are the common pitfalls to avoid? And if you have any questions, don't forget to write them in the comments. Welcome, Ainhoa, to Spainguru.
Thank you. Thank you very much. And
Could you briefly explain what the Spanish non-lucrative visa is?
of course, this is a residency, okay? And this term is important, residency, because this counts towards, I don't know, permanent residency, towards nationality, so Spanish citizen. So it's a residency that they first give for a year, and then we can renew it for 2 and 2. That allows you to live in Spain if you show that you have savings. What savings? We always say, like, to do a round number, we always say 30,000 euros, but really the law says an index, okay, that we have in Spain, that is IPREM, IPREM in Spanish, okay, IPREM, and it says that you have to show 400% of IPREM. That right now is around 27,000 euros. I always say 30,000 euros. So they give you this residency for a year, okay? And you cannot work in Spain as an employee or to have your own business, but it's not only for retired people. People that come to study, they can do it, okay? People that are coming for 1 year break, they can do it. And you can also even have income. That is what the people doesn't know. So, I mean, you can have a company if you want, but you need someone, okay, that administrates the company, who represents the company. So, of course, that if you have a company, you can have the shares, that 100% shares, but you cannot do anything with the company. You need someone who has the permit to work, who represents the company.
Who is typically eligible to apply for this non-lucrative visa? And I understand from your previous answer, there's no age limits for this visa, right?
No age limit. So it's true that retired people is a very common client. For me, it's a client, but
Right.
okay, an applicant for this visa. But a lot of students can come with this kind of permit, and they are young people. And it's true that in some consulates, they put problems, but really because the consulates don't know about really the law. And we have fight for a lot of cases for young people, because it's better for the future, the non-lucrative. The problem about the student permit, for example, is that you have to keep studying, keep paying studies. So if you meet the requiremms for the non-lucrative, you can choose more studies, not only the ones that qualify. For example, maybe you want some part online, you can do it. So there are a lot of advantages, as I told you, permanent residency, a lot of advantages, and there are no limits. Young people, old people, people that are in 30s, 40s, that they want to get a break, have a break, and maybe they are planning to work in the future in Spain, but now they don't know if they really want, and they want to live the experience and decide if they settle in Spain. These are very common situations.
Yes, I've heard from people of 20 in their 20s that applied and actually got approved for this non-lucrative visa. And that's why I always say consult with the experts from Sterna, because if you have an idea on how you want to move to Spain, I'm sure Sterna can actually guide you through the best path in order to fulfill your plans, right?
Most useful thing about doing a consultation is that sometimes we think we meet the requirements for a visa, and it's true, but maybe there is another visa that we also meet the requirements and is better for our situation. So the good thing about knowing the immigration law is that we know all the visas, and maybe is any other visa that you have not think about is better. And this is very common with the non-lucrative for the students, as I told you, and for the golden visas. The golden visas, which are the ones that invest money normally in properties, but there are different situations, is much better if they come with a non-lucrative and they check by themselves where they are investing, okay? And a way to come and have the time to decide where you invest is coming with a non-lucrative, because you just saw savings, and then you can switch, because coming with a non-lucrative allowed to switch, which is very important, to another kind of visas. For some of the visas before the year, for other kind of visas after the year.
What are some of the key documents required when applying for the non-lucrative visa?
Well, if you ask me, we will review everyone, but the key document I think is the private insurance, because there are a lot of common mistakes. Okay, you need a private insurance. Okay, for the private insurance, you need to show what we call condiciones particulares. It's called in Spanish, and it says what it is covered and what is not covered. It's very important for the non-lucrative that you show that you are covered for everything, with no copayments, copagos in Espanol, and also without carencias. We say in Spanish that is that period of time that you are not
waiting
covered.
times.
Not waiting times. For example, pregnancy. Pregnancy is a very common thing that they take it out for a year. Okay, that insurance will not be valid. So the certificate, the condiciones generales of the private insurance is a key document. Of course, criminal records, okay? It depends on what country you are, you know, it has to be for the whole country. Spainguru has a lot of US citizens. It's not valid the state one. And even if it's, I'm telling you this, and the law says that, I know that some states in the US, sometimes they accept it. And this is the crazy thing about immigration, that one thing is the law, and something else is what the person in the consulate accepts, okay? That sometimes it's better for you, like in this case, if they accept the state criminal records, and sometimes it's worse, like when they ask for the mortgage, okay? So in a non-lucrative, in California, it's very common that they ask for you with the non-lucrative to not have a mortgage, okay? And that is not mentioned in the law. You can have a mortgage. So these kind of things are difficult for the non-lucrative to know really what are your rights. If you have a mortgage, can you ask for a non-lucrative? Yes, you do. But then, depending on the consulate you are, you have to fight a little more. So some other documents. If you are married, marriage certificate. If you bring your family with you, normally the kids, birth certificate from your children. I'm telling you this, but every document which is not Spanish has to be with an apostille and an official translation, okay? The Ministry of Affairs has a list of all the people certified to be traductor jurado, okay? That are the people certified to do these translations, okay?
Sworn translators.
Sworn translators, exactly. And the other document that is a main document is the financial means, okay? The financial means. Normally, what we show, because it's what the consulates like the most, is a bank certificate saying that you have at least that amount that we said, okay? It's the 400% of the IPREM for the first one, for the principal.
Which is around 30,000 euros, around.
Yes, like 27,000.
27 plus.
Exactly. and 100% of the IPRM for the extra family members.
For dependents.
Okay? For dependents, exactly. So in addition to this certificate, which is like a letter saying from the bank, this person has this account and this money in the account, in addition to that, they want to see the last 6 months of movements, okay, of bank statements.
Right.
In some consulates, sometimes it's 3 months, but the normal case is 6 months. In that, in those bank statements, they are going to check if you are working, because they will check if you get an income, or if you didn't have the money and suddenly you have it, because it doesn't mean that you need to have 6 months that money in your account, because it's a very common situation that maybe you have invested in wherever financial product, okay, and you take it to the savings accounts to do the application. But they need to understand why you have it. Maybe you have sold your apartment yesterday and today you have the money. Tomorrow you can apply. But the way that they have to understand your situation, if you are working, if you are a profile that they think that you will continue meeting the requirements of a non-lucrative, are the bank statements. So we have to really take a look of what these bank statements show.
I think
and that are the main documents. Of course, a medical certificate is required, which is very simple, but those are the main requirements and the main documents that we will have to submit.
Yes, there's also one more that comes to my mind, but it depends on the consulate. I think UK consulates ask for it very often, which is the P45, which is a letter from the employer saying that you are no longer working.
They've been asking for this recently a little bit in order to make a difference, especially with the nomad visa. Okay, so now the UK is asking for this. But for example, the US just depend on the consulate also. For example, Miami.
They don't have the P45 form. They don't have it.
And they ask for a declaration at the notary. Okay.
Exactly.
So it depends a lot in the country, but yes, what they really make sure about it is that you don't work. Okay.
At least at the time of the application, you can't be working. And I've seen cases of people who are working, but promised, as you said, by a notarized letter. If they were freelancers, for example, they promise it that they are granted the visa. They no longer are going to be working as freelancers, right? That is the spirit of the visa, right?
Exactly, and that's why they are coming up with new visas like the nomad, because that is the spirit, but the non-lucrative is not really clear. Okay, so it's if you read the law, it's very simple and not very explained. So it says doesn't allow to work, but what doesn't allow to work for a company in Spain, or you cannot work at all, or can you have a company in your country? So that's why they are trying to be more specific in each visa.
How long does the application process usually take from start to finish?
The law says 3 months. Okay, normally it's sooner. In 1.5 months, normally we have it. Okay,
this is from the application. Of course, gathering documents,
of course,
it's a whole different story, right?
Yes, especially with the apostille of the criminal records. In the case of the US, that the apostille takes around 3 weeks. So it depends in the country, but from the moment you have everything complete, 1.5 months or less is the normal thing.
Can Sterna handle NLV applications at any Spanish consulate?
Yes, of course. So this application is only done at the consulates, okay? So the first non-lucrative visa is applied always at the consulate. And because of this, we can help you doing it in whatever country you are. In some countries, then make it, or in some states of some countries, they make it easier. Is everything a little bit more online? Some others are less modern and you have to be in presence, but in any case, we prepare all the packets and we send it to you if that is the case.
Yes, and in some consulates, all the consulates in the UK and now some in the States, they decided to outsource the visa processing through a company called BLS. Is
Yes,
that
and it's
something that really changed the process?
well, they even know less. So it's a problem, a huge problem, okay? I've been doing, for example, last week in Miami, which used to work very, very, very well. And it was a disaster, okay? So be patient if this is your case, and if you are facing by your own these companies, because they really don't know and they check a list. And sometimes you have a situation that is not exactly in the list. For example, I had a client that in Miami that couldn't give the passport. This client need to keep the passport.
Yeah.
And we asked for this permission. They tell us how to do it. The consulate told us how to do it, doing a notary copy of the passport, notarized copy of the passport. We did everything following the instructions of the consulate, and then because you submitted somewhere else that is in these companies, they didn't accept it. So what was my job? I am there for that, okay? I had to call again the consulate. I make them make sure that they talk to this company and they told them that my clients had all the right to submit the application. Because the worst thing about these agencies is that they don't even give you a document saying why they don't accept you. And it's your right. If they don't accept you an application, they have to give you a document saying that they don't accept you the application because whatever document is missing. And this is
Right.
because normally you have all the right to do the application, even if some documents are missing. It's true that there are main documents that you need to have, but not all of them. And this is very important because maybe if they don't accept you the application and you have to make another appointment, which maybe in the online calendar is in another month, maybe your criminal records are going to expire, or things like this that can make things very complicated just because it's in the middle an agency that doesn't know very well the procedure.
And on the side of the applicant, what are the main or most common mistakes people make when applying for a non-lucrative visa?
Well, the private insurance that I already mentioned, they get confused about the private insurance a lot. Also, with the apostille and translation of the documents, they get a little mixed up because sometimes, for example, they apostille the wrong document, okay? And also getting mixed a little bit of what they say and what they want to do, because sometimes they say, and it's correct, if you say that you come to Spain and you will decide that if you want to work or not, because it's correct, you can wait for a year and then switch your permit to a permit that allows you to work, or even earlier than a year for some permits like nomads. Okay, but when you say that, they become crazy because they think that you are going to start working without the permit, and that is not true. You are being honest about that you are coming to Spain, and then you will decide. But these kind of things can complicate a lot the application.
True, absolutely. Sometimes people say, why don't you say the truth, right? And of course, you should, but Spanish bureaucracy sometimes works in different ways, and small mistakes can become a big snowball, right?
It shouldn't be like that, but
It
it's
shouldn't
like
be like
that.
that, but all right. Next question. This is about the 6 months minimum stay requirement to renew the non-lucrative visa. Recently, there was a Supreme Court decision that actually erased this requirement. How does this change things?
Well, what the ruling has said is that this has to be this mandatory rule to be 6 months in order to renew has to be in a law, and right now is in a reglamento, in something under the law.
In the procedure, or
yeah. So until this is approved and the new law is approved, you could even renew the non-lucrative without being 6 months per year. That is your right. Okay, and now let's talk about the reality. The reality is that, as I'm telling you, people that work in immigration are not I mean the civil servants, the one that solves your application.
Actually sign your approval to renew.
Exactly. Normally they are not well informed, okay? And because they have the list of checking the passport and checking if you have been 6 months, even if there is this ruling, you could have a problem. And don't worry, because if you have this problem, you could do an appeal. And of course, there are 2 appeals, okay? One is to the office, the immigration office, and the other one is to the court. To the court, for sure, you are going to be successful. And to the immigration office, you should be successful. Why? Because the appeals are normally reviewed by the boss of the office, which normally has to be a little bit better informed than the people that is working below him or her, okay? So you are lucky if you haven't been 6 months per year. Try to renew it. You should be able to renew it, but maybe there is a chance that you have to do an appeal. Don't worry, because you have the right. You are going to win the appeal, but it's a little bit more uncomfortable.
Of course, and this has a very big impact, because one of the rules to become tax resident in Spain is to have spent 183 days plus in a calendar year, right? So 6 months minimum stay makes you a tax resident in Spain. So this could really change things. But unfortunately, right now, as you say, we are in a transition period.
Yes, so I think exactly. Exactly. They will approve the law, but right now, if you didn't want, because people that don't want to become tax resident, okay, what they do, because it's possible, is to apply every year for a non-lucrative. Maybe they stay here for 5 months, okay? So instead of renewing because they don't meet the 6 months period, because they don't want to become tax resident, they apply every year at the consulate for a new non-lucrative visa, which is not as comfortable as doing a renewal. So this for now is a very good opportunity for those people that were planning to do a new non-lucrative visa every year. They can do the renewal. The renewal is for 2 years, and you can not become at the same time tax resident, as you said.
But of course, now thinking more long-term, if you want a long-term residence permit, or as people call it, permanent residence permit, you need to be thinking about how long you're going to be staying in Spain for the previous 5 years, right? So this is something also to have in mind at the same time, isn't it?
Exactly. So one thing is being renewing the non-lucrative, okay? That, as we talk about, is okay right now. But the permanent residency, what we call larga duración, okay, asks you not to be outside Spain 10 months in the last 5 years, which is very, very tough to meet, okay? It's around 2 months per year. You can divide it however you want in the 5 years, huh? But 10 months in the last 5 years, of course, you will become a tax resident if you want to if you want the permanent residency. So there are other strategies, like the Beckham law. Okay, I'm not an expert in taxes. We have experts in taxes, but maybe if your long-term goal is the permanent residency, then you have to do a tax strategy to pay the less that you can, being here in Spain a lot.
Can NLV holders work remotely once they've been approved, okay, for companies outside Spain while living there?
That is a gray area in our legislation. The perfect visa for that is the nomad visa. They have designed the nomad visa for that kind of situation, but because it's a gray area, we could defend, okay, that yes, you can work for a company outside. There is a ruling also from the Supreme Court talking about taxes, okay, from a non-lucrative that yes, could work for his company outside. It was before the nomad. And this is because the nomad visa, the non-lucrative visa is not very clear. As I told you, it's very short description of the rights. So depends on the interpretation of your lawyer and the interpretation of the courts. I haven't seen any problem. If you are asking me, I haven't seen a person with problems about working remotely, okay? But it could be something that they want to check and could possibly be a problem that I think we can easily fight. But I cannot tell you that it's clear that you can do it.
Absolutely. Well, me personally, over the years, I've met people who are on non-lucrative visa that were approved at their consulates and are working remotely for companies outside of Spain. They are paying taxes in Spain. They're not paying Social Security though. But as you say, it's a gray area. Nothing has happened. They have been living here for years, and this is the situation. Then one day, more than 1 year ago, the digital nomad visa or teleworkers visa was approved, and it seems to suit more that figure or that kind of activity. But still, the non-lucrative visa has not changed. It didn't become more specific, more clear about this. Just the consulates decided individually to be more strict and apply certain interpretations of the rule. But this is the situation. Correct me if I'm wrong.
No, you are completely right. That is the exact situation. And also we have the problem that the nomad visa hasn't been 100% successful and useful, okay? Because there are agreements in Social Security, especially with the US, for example, that doesn't cover you as a nomad, only as an intra-company. So in the end, it's only valid for freelancers. So in the end, nomad teleworkers that are employees doesn't have any other option that doing a non-lucrative and working from here. It is correct. I don't know if it's completely correct, but it's also not 100% incorrect.
What is the renewal process like for the Spanish non-lucrative visa?
Well, the renewal is much easier than, if you meet the requirements, of course, than the first application, because it's done online, okay, with copy of all the documents. You don't need criminal records again. You don't need, the marriage certificate again. So the application is done online 2 months before to 3 after. It is recommendable to do it 2 months before, because the law says that they could give you a fine of doing it 3 months after. I haven't seen it in all my life, but it says so. And it has to be approved in 3 months, okay? If it's not approved in 3 months, it is a mandatory approval for immigration. They cannot deny it. This is very important, okay? But it is very important, if this happens, that you submit a positive silence document, which you say, it's been already 3 months from my application, you haven't said anything, so it has to be approved, okay?
And Ainhoa, what are the tax implications for Spanish NLV holders?
Well, what you have to make sure is your non-double taxation agreement normally, because even if you don't live in, if you don't work in Spain, even if you don't work in Spain, you have lived 183 days. So you are a tax resident in Spain. And because you are a tax resident in Spain, you have to declare taxes in Spain. Something different it is that if your agreement, the tax agreement between your country and Spain says, like in the US, that you pay everything in the US, then you don't pay here, or the other way around. Maybe you have an apartment here in Spain, okay, which you are renting, because you can do that. And if you are renting, you are getting an income. And if you are getting an income, that income is in Spain. For example, that situation, you will pay income and you will not pay it in the US, okay? But you have to really check your bilateral agreement and your tax advisor. But what you need to understand is that maybe you don't have to pay taxes, but you have to declare taxes. You have to declare your situation and show that you have paid your taxes in the other country.
So as you said, in Spainguru, I think most of our viewers are from the US and the UK. And fortunately for both of them, there are double taxation agreements that
if you Google them,
avoid paying double, right? I think the US, the threshold for 2024 is $126,000 that are, let's say, protected by this agreement. It means that if you make over that, then you will have to pay taxes for that amount over that threshold. But of course, as an American, you always have to file, right? Just because of holding the American passport.
Yes.
This is even if you don't pay, because normally Americans will have to pay first Spanish taxes, and then they will credit those taxes, which are usually a bit higher than the American ones, not that higher, and then they will just file and credit that difference, let's say, and not having to pay to the US. This is the way it works. Long story short, of course.
Exactly. Long story short, because if immigration is personal and depends on your personal situation, taxes even more. So I think it's very important to get advice in your personal situation.
Some consulates require an address in Spain, such as a rent lease, at the time of the application. How should applicants manage their housing arrangements before arriving in Spain?
I recommend all my clients, and I recommend all the viewers not to do that. It's not safe to rent a place without seeing the place. What I do is saying where my client plans to live, in what city, in what area. And sometimes I say the normal price. I go into Idealista. This is a very common website in Spain to rent places. Yes, there are several, but like a list from there of the listing of the properties, and that I will check some of those, which is not mandatory. It's just to give them something. They want something, they shouldn't want that, but at least you give a list of, okay, I plan to live here. Then you can change your mind and go to another city or not rent there. Sometimes I also recommend, if you have a friend, a family, someone that can write a letter and tell them that they allow you to stay at their apartment until you find something. I also do that. Okay.
So for example, in consulates like Chicago and Houston are famous because of this requirement that, it's a little bit too much, right? So what would happen if they ask for it?
That doesn't make sense. Imagine that you lease a place for a year and they don't approve the application, your visa. So it's something that doesn't appear in the law. It doesn't make sense, and it's not safe at all. I always fight this, and they always allow it in the end to do the application without doing the rent agreement. And I fight for a lot of things, because for that they hire me. But I think that this is very important for you not to do it.
And they are in good hands if they go with you. Now, can non-lucrative visa holders eventually apply for permanent residency and even Spanish citizenship?
Of course. This is a very good residency, because as I told you in the beginning, it counts for permanent residency, it counts for passport. Really, every residency counts for this. What it doesn't count is the student permit, okay? If you are a normal student, or if you are an auxiliar de conversación that you have a student permit, doesn't count for permanent residency. It counts as a student 50% for the European Union, okay? But never for Spanish citizenship, okay? So that's why I'm telling you, maybe your situation is that you come to study, but maybe if you want the Spanish passport, maybe it's better to come directly with the non-resident, with the non-lucrative.
With the non-lucrative visa, one of the hidden benefits of coming to study under the NLV instead of choosing a permiso de estancia, which is not a residency or a student visa, right?
Exactly.
Many of the viewers have dual citizenship or can have it from Ibero-American countries such as Mexico, Puerto Rico, Guatemala, and Philippines as well. And they ask me, like, can I apply? For example, they live in the States and they are American, but they also hold a Mexican passport. Can I apply for the non-lucrative visa with the American passport and then use the fast track, the 2-year application by residency period for Spanish citizenship with the Mexican passport?
Yes, they can. This is a very common question, and it's a very good question, because I think it's the only situation that the law says one thing, which is that you can't, I will explain now, but that they are allowing to do it, okay? So if you read the law for the Spanish nationality, it says that you need to have the residency as the nationality with the passport that you want to show to get advantage of the 2 years for the Spanish passport. Means that if you are American and Mexican, you need to have the residency as Mexican if you want to apply for the passport after 2 years. This is what the law says. But there was a meeting, online meeting, that was recorded by the person that coordinates the Ministry of Justice, because this Ministry of Justice is the agency that approved here in Spain the Spanish nationality. And they said, and they are doing it, because I have a lot of cases, that even if you have the residency with the other nationality that doesn't give you the fast track, like the US citizen, they will give you the chance to do the application of the nationality, having into account that you have the other passport that give you the fast track, so you can do it in 2 years. This is very important, and because there are some consulates that if you have that dual citizenship, they give you the residency with the passport of the country that you are applying for. So someone that is in the US, even if it's Mexican, if it's applying for the visa, they give it to that person as a US citizen. And look, California, which is very difficult for everything. California, I've been successful asking for the residency with the other passport, with the Mexican passport. Okay, but even if you are not successful, or even if your consulate doesn't allow you to do it, they are approving these nationalities after 2 years, even if you have the residency with the US or any other passport that doesn't have the fast track. So good for you.
What are some of the common legal hurdles that we haven't mentioned so far, or challenges applicants might face?
really the main difficulty are the consulates, okay, and or the agencies, as we mentioned, that they use to accept the documents. Because if you read the list of documents that you need, taking out these kind of things of the mortgage or renting a place, which is a little bit more complicated, all the others are very simple. But is the visa which they give more problems. It is much easier to do a nomad, to do an intra-company, to do a highly qualified, than doing a non-lucrative, which should be simple. But consulates are not very welcoming, depending on the consulate, on the person, and also in your profile. A retired person normally is more welcome, you know, because they have less doubts. But it's not an easy application, and it should be. I know that should be an easy application, but can get really complicated.
Actually, on Spainguru, I have an article about 11 differences between the consulates.
Yeah, good.
Yes, and I have a video about it. I will share the link here. It is funny to see the differences in the consulates, but of course you can't choose your consulate. You have to be a legal resident of the jurisdiction of your consulate. For instance, if you live in, I don't know, Florida, you have to go to Miami. You can't apply for the non-lucrative visa in LA unless you, another important question, can one transition from a non-lucrative visa to a digital nomad visa? And why is this key? Because supposedly under a non-lucrative visa, you can't work. And for the digital nomad visa, you need to prove that you have been working for a certain time for a company that has existed for a certain time, right? So it feels it's a bit contradictory.
Yeah, these are the nonsense things about immigration. Is that it's true that the nomad visa asks you to have been working at least the previous 3 months, okay? And you can apply with a non-lucrative, and you can also apply with a student permit. Two situations that are in the gray area because you shouldn't be working, but they know that it's a gray area, and immigration has clarified in written, so it's not something that is not is in the air. So it really is in written that you being a student or being a non-lucrative, you can switch to nomad visa, which is very good. And the other way around, okay? We have said that the non-lucrative, the first non-lucrative has to be applied in the consulate. But if you've been 1 year with another kind of visa, okay, you can apply for non-lucrative from Spain. So if you've been a nomad for a year, you can switch from nomad to non-lucrative after the year. This is very common with the highly qualified workers, because the highly qualified workers are attached to the company. When they lose that job, they normally don't have a solution so fast. So what they do is switch into a non-lucrative, because normally they have 30,000 euros in savings, switch into a non-lucrative after the year if they lose the job or they are not happy with the job after the year. And then when they find another job, they switch again to highly or to cuenta ajena. That this is for another video, but sometimes it's better cuenta ajena than highly qualified worker.
Kind of support services that Sterna provides post-visa approval?
Well, you know that, and this is something that freaks out people that are not very well informed. When they give you a visa, it's only a visa of 3 months. The non-lucrative visa, the visa that they stamp you in the passport, is only of 3 months. This is because there are some things to do in Spain which are covered by us, which are empadronamiento. The empadronamiento is the enrollment like in an address, okay? Because you lease a place or because someone allows you to live in their place, doesn't make a difference. Or you can switch empadronamientos as many times as you need, because sometimes you don't have the main address in the beginning. But in order to do fingerprints, to have the card of 1 year, you need to be empadronado, okay? So first we need to register your address, even if we switch it again, and then we make an appointment for you. That also is a simple process, becomes very complicated because there are no appointments. And you go to the appointment of immigration with your empadronamiento and the passport and a tasa that we pay for you, or you give it, or we give the documents for you and you go to the bank, depends on the client.
And then you get the TIE, no? You get after the fingerprints, you will get the tarjeta de identificación de extranjero.
Not immediately, after normally 3 weeks, depends in the city, okay? And this has to be in person. I cannot do it for you. You need to pick the TIE, okay? Because a lot of clients want me to go and pick it for them. I will love to do that, but it's mandatory for you to go.
Right, this is the police, and the police want to see you, right? As a person.
Exactly.
Let's make sure that you are the one holding that visa. So the visa grants you a window of 90 days to come to Spain, and once you arrive, you have 30 days to provide empadronamiento, get the fingerprints, and
they are not so tough with those 30 days because there are no appointments.
Because there are no appointments. So
exactly. So don't worry. Of course, try to do it. If you don't have 6 months left, okay, they are not going to issue the TIE. If when you go to fingerprints, there are no 6 months left. They are not going to issue a plastic because they say that there is very little time of validity, but that doesn't mean that you become irregular, okay? They are flexible, but don't be relaxed. They are flexible when they know there are no appointments. If they know that they are appointments, they are not going to be flexible, okay?
And handles cases where a non-lucrative visa application is initially rejected.
We decide if we do an appeal or a new application, okay? You can always do a new application, and you can always do an appeal if you are in time. You know that it's 1 month from notification to the appeal to the consulate and 2 months to go to the court. The problem about doing the appeals, okay, or the new applications is if you have shown something that they really don't like that you work because of this gray area, that you work even if it's in your country, and in that consulate they have the criteria that you cannot work, it's going to be difficult, and it's going to we will have to really prove them that you have understand that you cannot do it, and that you will not do it then with a declaration at the notary, things. So when there is a denial, sometimes it's very simple. It's a mistake from the consulate. It's very simple to do it again or to do the appeal. Normally is quicker if you do a new appeal, but you need to pay the fees again. Sometimes if it's something that we really have to fight, then we have to do the appeal because we have to really give reasons not to deny it, and we have to go to the court. But the problem is if you have shown something that is not very good to show to some consulates.
And obviously, if you were handling this dossier, if you were handling this application, you will already know what looks good and what doesn't in order to avoid potential problems down the way, right?
For me, it's much easier to do it from the beginning than doing the appeal. And normally the appeal is more expensive for me than the first application, because fixing something is a little bit more difficult sometimes, depends in the case, than doing it in the way that we know that consulates like it from the beginning.
Well, thank you very much, Ainhoa, for sharing this knowledge with us. I'm sure it helped clarify many of the questions I had and the viewers had. And of course, if you want to contact Ainhoa at Sterna Abogados, you can find the link in the video description and in the pinned comments. She will be ready to help you out, fulfill your dreams about moving to Spain under a non-lucrative visa or any other visa that suits you best. Thank you so much, Ainhoa.
Thank you very much. We keep in touch and we will check the questions that they have.
Fantastic.
Thank
Bueno.
you.